So we just had oral arguments in the Rhode v. Becerra case, and there were some interesting things that came out of this, so let's talk about it. But real quick before we jump into this video, if you think that California's laws regulating ammunition sales violates the Second Amendment, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main sponsors of the channel, and that is Thorson Customs. Thorson Customs does more than just provide California compliant parts to patriots in California like me and you. They also support various legal actions which are actually targeted at abolishing those laws which make their parts relevant in the state of California. So Thorson is an amazing company. They do a lot of things for gun owners. So if you've been interested in taking a look at them, I'll put links in the details to Thorson. I also want to give a shout out to another major supporter of the channel, and that is Got Your Six. For just $2.99 a month, you get access to a lot of amazing things on their app. One of the neat features is they have this button called Initiate Freedom, and if you click that, a notification goes out to those members of your group, and it's kind of an Amber Alert for firearms owners. So it's a really cool company, a really cool app, and if you guys are interested in taking a look at them, I'll also put a link to them down the details section. So Rhode v. Becerra, this is one of those very high-profile cases originating out of the state of California, and it revolves all around the various regulations that the state of California has on ammunition sales, on ammunition purchases, and specifically the eligibility checks, also known as background checks, that the state of California has placed on ammunition sales. I'm not going to talk comprehensively about what Rhode v. Becerra entails, because I have multiple videos on the channel that discuss that, and you can actually click this tab right there and it'll take you to a whole playlist where I discuss this case, the various topics and things that have arisen. So this case originated in the Southern District of California before the Honorable Roger T. Benitez, or St. Benitez as he is called in the state of California, and Judge Benitez issued what is known as a motion for preliminary injunction, or granted a preliminary injunction in favor of us, and it essentially benefited California gun owners. Well, when he did that, the state of California and their representatives in the AG's office decided to appeal that specific granting by Judge Benitez, and they appealed that up to the Ninth Circuit. And now the Ninth Circuit today heard arguments on that specific issue, and we're primarily discussing and had to decide whether or not Judge Benitez's grant of that motion for preliminary injunction was proper or not. So that's what this all entailed. So I just want to talk about some of the main things that we saw pop up in these oral arguments and some things that gave me concerns and just some of my general thoughts after watching this. And then at the end, I'm going to talk about my general takeaways and whether or not I thought this went good for us or bad from us. And I'm sure from the title and the description and the thumbnail, you can tell what I think this might be leaning towards. So first and foremost, one of the main topics that we saw pop up, and one of the first topics we saw pop up, had to do with this distinction between the basic eligibility check and the standard eligibility check. If you're not familiar, in the state of California, when you go and purchase ammunition, you have to go through an FFL. And what happens is you get run through either one of these two eligibility checks or background checks based on exactly what you're gonna do. You can go through the standard streamlined process if you are in California's AFS system. If you've purchased a firearm, if they have your information, all of that, you will be in the AFS system. You pay a $1 fee, and it's what the state calls a streamlined process. If you don't have any of that information in the AFS system, or even if you are denied the standard eligibility check, you can go what's through the basic eligibility check. And what happens there is you pay a $19 fee, and then you have a waiting period attached to that as well. So there are two different kind of avenues you can go through in the state of California when you're purchasing ammunition. What the state's main arguments were in regards to the standard versus the basic eligibility check was essentially that even if you failed the standard eligibility check, which was one of those main topics that was brought up before Judge Benitez in the lower court, and it was this number of almost 15% of all individuals who tried to go through a standard eligibility check were denied. And these were lawful individuals who otherwise were not prohibited people, or we don't even know if they're prohibited people, were actually denied their ability to exercise their Second Amendment rights, be able to purchase ammunition in the state of California. But the state's argument is that the standard eligibility check is simply a streamlined process. And even if maybe this infringes on your Second Amendment rights, or if it's not perfect, if you're denied under the standard eligibility check, that's just simply a streamlined option that individuals in California can go through, but they also have the basic eligibility option that they can go through as well. Simply, according to the state of California's representative, this standard eligibility check process or avenue you can go through is simply optional. It is the state of California saying, hey, we're gonna try to help you go through this process faster. We're gonna give you this faster option, but if it doesn't work out for you, you can still go through the basic option that's longer, higher fees, all that stuff. So isn't that nice of them to infringe on our Second Amendment rights, give us a faster or streamlined option, but even when they pretty much fumble that option as well, do a horrible job implementing that, infringe on our Second Amendment rights, they still have this other, more costly and actually longer process that they offer to us. Isn't that nice? Our representative, when she was asked about this distinction between the basic eligibility check and the standard eligibility check, she hit heavily on the fact that, and all the evidence that we had in the lower court before Judge Benitez, talking about 15% of individuals who tried to go through the standard eligibility check were denied. Even though they were lawful individuals who should have been able to purchase ammunition, they were still denied their ability to do so. She also hit heavily on this amount of fee with the basic eligibility check being $19 along with the waiting period. And what she said, and pointing to the statistics which are put forward by the state of California itself, it shows that individuals who went through the standard eligibility check and those 15% of individuals who were actually denied that standard eligibility check, almost, I think it was more than 55% of those individuals then did not also go through the basic eligibility check. So even though the state says that the standard eligibility check avenue is a streamlined process, but even if you fail that, you still have this other option available to them. What the evidence and record showed is that individuals, after failing the standard eligibility check, did not exercise their ability to go through the basic because the basic is way more costly, and also you have that waiting period attached to it. So the basic versus standard eligibility distinction and kind of what the state's opinion on it versus our opinion on it was one of the main topics that was brought up. And there was a lot of questions asked by, I believe, Judge Woodford on it and also Judge Bumate. There was also heavy discussion on another topic, and that was, is the ammunition eligibility check or background check permissible under the Second Amendment? And of course, the state representative, when he was asked this question, said, if you look at Ninth Circuit precedent, I believe it was Sylvester, the Ninth Circuit has indicated that 10-day waiting periods and background checks on firearms is permissible, doesn't burden the Second Amendment, passes intermediate scrutiny, and therefore similar restrictions on ammunition sales would also pass constitutional muster. Our representative has a much higher hurdle she has to jump, mainly because there is that court precedent. First, she distinguished ammunition eligibility checks or background checks from firearms background checks by saying that ammunition regulations, first and foremost, are not historically rooted. We don't have a ton of states that do ammunition background checks. In fact, the state of California is the first state to ever do anything like this. And also, she pointed to the fact that ammunition background checks is extremely duplicative, mainly being that individuals in the state of California who are felons or prohibited persons already aren't supposed to purchase firearms, have firearms, or have ammunition. On top of that, then you also have the background check and waiting period that are implemented on firearm sales. But then the state of California goes even further and says, hey, we have to add a third level in requiring background checks on ammunition sales. So what she argued is that we have extremely duplicative laws, and if you take what the state of California says and why they need to actually have firearms background checks, all these individuals who are prohibited individuals who aren't supposed to have firearms, who aren't supposed to have these items, should have already been filtered out. So you don't need this additional background check for ammunition. Another main topic that was asked primarily by Judge Bumate, and the question he kept asking had to do with severability. And he asked both sides this. He was asking, well, what can I do, or what would you say if maybe the court here, the Ninth Circuit, finds maybe the standard eligibility checks to be a violation of the Second Amendment? Then what happens with the basic eligibility check? Do we leave that alone? Do we have to wipe out the entire statute? Can one exist without the other? And that's what severability is. Can he sever one aspect of the statute from the other aspect of the statute, essentially sever? And both sides, both our representative and the state's representative, pretty much said that the way that California wrote this ammunition structure and eligibility checks and this whole web of things that they've come up with, it would be hard for one side or one check to exist without the other. Now, the last thing I want to hit on is one of the aspects that our side got hit heaviest with, and that had to do with standing. And when it came to the standing issue, that is when you had Judge Parker finally come alive. And if you watch the oral arguments, Judge Parker was very critical and actually very short-fused with our side when it came to the standing issue. Now, but I think what happened is maybe after a long day, because this was the last case on the docket that these three judges heard, and after some back and forth with our representative, he got very, it seemed like short-tempered, kind of snapped at the representative of ours, and I think maybe kind of went downhill after that. So there was a lot of discussion, and I actually have a lot of concern now about the standing issue, especially because Judge Parker hit heavily on this, and it's been one of those areas of contention. Now, I think this goes back down to Judge Benitez. He won't have a standing issue, but I'm just looking forward and kind of just reading the tea leaves, because ultimately what happens, even though this might go back down to Judge Benitez in whatever form, depending on what the 3-judge panel does here, whenever Judge Benitez has his final judgment, this will be appealed back up to the Ninth Circuit after that final judgment. And the standing issue could come up again and can be a very significant issue again. So when it comes to the judges, I think it was pretty evident, at least for Bumate and Woodford, they were exactly who we thought they were going to be. Judge Bumate, if you had watched some other 3-judge panel oral arguments, he's very Second Amendment friendly. It seemed like he was trying to find avenues to help us along. And when it came to Judge Woodford, he's an Obama appointee. I think he was very critical of our representative, wasn't so critical of the AG's representative. And I think that just falls in line with what we thought would happen. Now, the wild card was always going to be Parker. And after watching this, I have some general takeaways. One, he didn't, I think, ask really any questions originally from the AG's representative. After the 2-minute reserved response, he did ask some further questions of the AG's representative, but I think he was much more critical of our side and asked some very critical questions of our side. And based on his demeanor and questions and some of the back and forth, I actually think that he may not be leaning in our favor. Now, I could be wrong. That can maybe just is his demeanor. I don't know. I've never actually watched him. So what are my general takeaways? Well, I think you can guess by looking at the thumbnail and the title that after seeing the demeanor of some of these judges, I think Bumate was definitely in our favor. I think Woodford is definitely not in our favor. And I think after watching Parker, seeing some of the questions, seeing how they're fielded, I don't think Parker's going to go in our favor. This potentially could not go in our favor. I think they could say that Judge Benitez created some sort of error. So what does that do? Really what's going to happen is if it doesn't go our way, they're going to say, Judge Benitez, you created some sort of error in granting the motion for preliminary injunction. You need to consider X, Y, and Z. And then they're going to give that back down to Judge Benitez, and then he probably will not grant the motion for preliminary injunction. He will take that off the books, and then the case will proceed forward. So that's what that looks like. It's not going to be something super detrimental to us. Now, it's unfortunate because we would want the Ninth Circuit 3-judge panel here to affirm the motion for preliminary injunction and for that to stay in effect during the remainder of the lower court trial. That would be best case scenario for us, but based on some of the discussions like I mentioned before the 3-judge panel, I don't see this going our way, but I could be wrong, and I would be glad if it went our way. So that's my takeaways on Rhode v. Becerra. If you want to watch it for yourself, I'll go ahead and put a link in the details section so you can watch this. It's at the very end of this video, and also sometimes the videos get pulled, so I'll try to keep updating the link if the video gets pulled, but just keep in mind it's at the very end of all these proceedings because they had multiple cases before them, so they didn't hear this till the very end. So if you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is like, comment, subscribe, and make sure you hit that notification bell because it helps your channel analytics, helps us spread the word about the Second Amendment, also spread the word about things like this that are going on in the state of California. So as always, thanks you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.